have a few moments to complete some paperwork here, and then we will proceed with the final arguments. The claimants' team is the University of Sydney, and the respondents' team is the University of Queensland. Okay. I see we have a sheet of paper that is called an agreement as to order of arbitral proceedings, and I just want to be sure as to what's going on here, that the first speaker for the claimant will speak for 14 minutes, and then we will hear from the first speaker for the respondent, the second speaker for the respondent, the second speaker for the claimant, with reservation of 1 minute for rebuttal to be delivered by the first speaker for the claimant.
Yes, ma'am.
That's correct? Well, we have the administrative work out of the way. We invite you to begin your case.
Madam President, members of the Tribunal, in March 2016, the claimant time-chartered the vessel, the Thanos Quest, to the respondent for an express duration of about 50 to 55 days without guarantee. It was not until 93 days, however, that the vessel was redelivered, and when it was redelivered, her hull was thoroughly fouled. In that period, the claimant lost the next fixture, which it had negotiated with Champion Chartering, and with it, the hire to which it was entitled for the next 2 to 4 years. The present claim therefore turns on whether the respondent breached two obligations that it owed to the claimant under the Charter Party. First, an obligation to redeliver the vessel prior to the expiration of the maximum period of the Charter Party, and second, an obligation to clean the vessel's hull prior to redelivery. Turning first to our submission on late redelivery. Our submission on late redelivery is composed of two parts, breach and damages. Turning first to breach, we note that breach is not an issue in the present case because it has been conceded by the respondent at paragraph 1 of their written outline that it has been made out in the present case. In those circumstances, we therefore turn to the issue of damages. Our submission on damages has three parts. First, on causation, second, on remoteness, and third, on mitigation. Turning first to causation, in respect of causation, because the next fixture here was comprised of two periods, that is, an initial 2-year period followed by a 2-year option.
How certain was the second period?
On our submission, we need to establish in the present case that there was a real and substantial chance.
Yes, but I thought you said initially that there was an express term, and if it was an option, how certain was it?
On our submission, it was certain, or relatively certain, that they would exercise that option.
In whose favour was the option?
Apologies.
Who had the right to exercise the option?
It was Champion Chartering that had that option, and on our submission, we need to show that there was a real and substantial chance they would have exercised it. Our submission is that they would have done so for three reasons. That's first, because by exercising the option, they would avoid the difficulty of having to renegotiate a new option or fixture into the future. That's commercially advantageous to a chartering company who is regularly engaged in contracts of carriage. Secondly, we submit that this option afforded the Champion the opportunity to fix for future contracts of carriage well into the future, that being over a period of up to 4 years. And given that that is also commercially advantageous, they would have been likely to exercise it.
Wouldn't it have depended on the market rate at the time that the 2 years came up?
The market rate may have had some impact, yes.
Well, it would probably have quite a big impact, wouldn't it? It would be whether it was above or below the market rate and what they thought would be happening in 2 years' time.
We accept that that is likely to be decisive, Mr. Arbitrator. Right. Unfortunately, there's no evidence in the record as to what the market rate was in that period of time, and so our submission relies on other factors that we can draw inferences from on the record.
But if there's uncertainty about the future market rate, then how can you still be arguing that it was more likely than not that the option would be exercised?
Because on our submission, Madam President, those other two factors, even though there is some uncertainty as to the market rate, indicate that there was still a real and substantial chance, as opposed to merely a speculative one. We note that, however, if the tribunal is not with us on this submission, we submit that causation is made out in respect of the initial 2-year period, as has been accepted by the respondents at paragraph 2 of their written outline, and that in those circumstances we should still be able to recover for those initial 2 years, even if not for the 2-year option. Turning then to the question of remoteness, in relation to remoteness on our submission, the relevant test to be applied here is the test that was outlined in the case of Hadley and Baxendale. That is that a loss will not be too remote where it arises in the natural and ordinary course of things, or it is a loss of which a party had special knowledge. Counsel for the respondent have submitted at paragraph 1A of their written outline that their written memoranda that the test to be applied in the present case is the Hadley and Baxendale test as modified by the House of Lords in the 2008 decision of the Achilles. On our submission, however, this is not the case because a suite of subsequent cases have held that that test for remoteness, that is the test in the Achilles, is to be confined to unusual cases. Our submission is that here, this is not an unusual case, and that is for 2 reasons. The first is that in the Achilles, there were extensive market fluctuations in the price of hire, specifically as much as $8,000 in a given day, and here that is quite plainly not the case. Secondly, however, we submit that the expectations of the market now are different to those that they were at the time of the Achilles. Namely, at the time of the Achilles, it was thought that it would never be possible for an owner to recover for loss of hire under a next fixture. However, that is no longer the case because cases such as the 2010 decision of the Sylvia have held that in certain circumstances, loss of hire under a next fixture will indeed be recoverable. We submit, therefore, that this is not an unusual case and that the test to apply is the test in Hadley and Baxendale, namely the first limb, losses arising in the natural and ordinary course of things. If the tribunal is minded to find, however, that it is the test in the Achilles or the second limb of Hadley and Baxendale that is to apply in the present case, we submit that there has been an assumption of responsibility as required by the test in the Achilles, or that there was special knowledge on the part of the respondent.
What's the basis for your assertion that there was special knowledge on the part of the respondent?
We refer specifically to page 1 of the record, which is the spiral-bound book in front of the bench. Specifically, we rely on the 2 chatter posts that were published. It's our submission that there was sufficient information in those posts to inform the respondent that there was a follow-on fixture. And that's because those posts notify that the claimant in the present case was intending to fix for 3 to 5 years with the vessel in question.
Well, you might be able to make that argument on the basis of the second post, but certainly I do not see how you can make it on the basis of the first.
If the tribunal is minded to find that the first is irrelevant, we would be happy to concede.
Yes, you might as well move on from those weak points.
Of course, Madam President. In those circumstances, we submit, therefore, that they did have the relevant knowledge to assume responsibility, and that's because in the Achilles, at paragraph 36 of his judgment, Lord Hope recognised that what a party needs is some information which will allow him to assess the extent of any liability. Here, the respondent knew that we were looking to fix a medium to long-term fixture for 3 to 5 years, and as a commercial party in the market would also have been aware of the market rates in determining the rate of hire. In those circumstances, we submit that they did have special knowledge, or at least the amount of information they needed to assume responsibility for that loss. Finally,
is it true, though, sorry to interrupt you, that really any, you're essentially saying that any charterer knows that an owner might fix. I mean, that's what it actually comes to.
in respect of causation, yes.
Yes, because I think the Achilles is looking for more specific knowledge, because the nature of the beast is that people will always fix their ships, and they'll fix them for longer or shorter periods depending on how they see the market and things. My instinct is that the knowledge here is just the general knowledge that ships are fixed. It's not actually very, very specific, if I may say.
With respect, Mr. Arbitrator, we would disagree with that characterisation, and that's because in the Achilles there was no, for example, post that the respondent had seen, or the charterer had seen, so as to be able to know even the period of time in question for which there was likely to be a fixture. So here we don't just rely on the fact that there is likely to be a follow-on fixture, it's that is so, but that in addition here, there was a specific post identifying the extent of that particular charter, and that in those circumstances it can be distinguished.
But there's nothing about a particular charter in that post of March 1st, just simply says looking to fix for 3 to 5 years.
Our submission is that, given that the claimant in the present case is an established owner of vessels when it comes to medium to long-term fixtures, and we know that because in the first charter post they refer to adding to their existing fleet, it would be reasonable of a charter to assume that when they are interacting with an established commercial party, indeed one with a fleet of vessels serving this particular market, that it was likely that they would indeed be able to achieve that particular intention.
Well, that's a good submission, but you are imputing some knowledge to the charterer, which seems at odds with your prior submission that they had special knowledge.
Apologies, Madam President, that they did have special knowledge. It's our submission that they did see these posts, and that was the special knowledge that was being constituted in question. Briefly on mitigation before I turn to my second submission on hull cleaning, we accept, as has been noted by the respondent at paragraph 3 of their written outline, that a deduction should be made for any losses that the claimant has recovered, namely those recovered under the fair wind fixture. Turning then to the second issue of hull cleaning, our submission on hull cleaning is structured in 2 parts. That is, first, that the respondent breached an obligation to clean the vessel's hull pursuant to clause 83, and second, that the respondent is accordingly liable in damages. Turning first to breach, the relevant clause here is clause 83, which can be found at page 16 of the record. Clause 83 establishes that where a vessel remains idle in a non-tropical zone for a period of 30 days or more in accordance with charterer's orders, and the hull then requires cleaning due to fouling, that cleaning is to be undertaken by the charterer at their own cost, risk, expense and time. As can be seen from paragraph 4 of the respondent's written outline, the respondent does not contest the existence of the cleaning obligation or its application in the present case. Rather, they contest that subclause D is applicable. Subclause D provides for the situation in which a charterer is prevented from carrying out this cleaning, and it provides that where that is the case, the parties are to agree to a lump sum payment in full and final settlement of the owner's costs. Our submission on clause D is that, firstly, the respondent was not prevented from cleaning within the meaning of clause 83D, and that accordingly it was not enlivened. Therefore, the respondent did breach its obligations to clean. But second, and in the alternative, even if subclause D was enlivened, the damages to which the claimant is entitled for a breach of subclause D are the costs that the claimant incurred at South Island. So turning first to the issue of prevention, we submit that the respondent was not prevented from cleaning the vessel's hull in the present case for 3 reasons. That is, first, because whilst we accept that they were unable to clean the vessel at Wahunda, on our submission this is insufficient to constitute prevention within the meaning of subclause D. And in support of that proposition, we rely on an arbitration of 2014, specifically arbitration number 18, which we note is not binding on this tribunal but should be considered persuasive, where it was held that the unavailability of cleaning at one port is not sufficient to constitute prevention of cleaning obligations in their entirety. Secondly, however, we submit that it was well established and well known that the respondent could have cleaned the vessel at South Island. South Island was within Wahunda range and therefore was within the range for redelivery contemplated by the charter party. The respondent has contested at paragraph 8 of their written memorandum that it was commercially impractical to clean at South Island because to cause them to clean there would exacerbate their breach of the charter party, namely late redelivery. On our submission, however, this does not constitute prevention for the reason that here the liability which the respondent was liable for as a consequence of breaching their redelivery obligations did not extend based on the number of days that the vessel was redelivered late. Rather, the late redelivery of the vessel after June 28th, which was the end of the lay-can period for the next fixture, would have resulted in liability of the kind for which we are claiming. And in those circumstances, given that the vessel was not discharged of its cargo until June 29th and even redelivered until June 30th, they would have breached that obligation regardless.
Thank you.
Thank you.
Good afternoon, Madam President and members of the Tribunal. My name is Mia Williams, and I appear for the respondent Amiga Chartering Limited with my colleague Mr. Jonathan Hull. And I will be making submissions in response to the two claims brought by the claimant today with respect to the cleaning of the vessel's hull and the late redelivery of the vessel. And I'll turn first to late redelivery. You've heard from the claimant here that it is entitled to recover over $15 million in damages for the loss of a follow-on fixture which was cancelled by the subsequent charterer. We do admit that the respondent breached the charter party by redelivering the vessel late, and we do not contest that our client is liable to pay some damages for that breach. However, we submit that these damages must be limited to the difference between the charter rate and the market rate for the period of overrun, that being a period of 38 days. As opposing counsel noted, the heart of this dispute is whether the loss is too remote. We do not disagree that the appropriate test to apply here is the test from Hadley and Baxendale. The loss will only be recoverable if it falls under the first limb, that is, a loss arising in the ordinary course of things, or the second limb, a loss within the contemplation of the parties. Turning to the first limb, and this is at paragraph 1A of our written outline of argument, we submit here that the 2008 case of the Achilleus is directly on point and that the same result should follow. The House of Lords unanimously held in that case that a loss of profit under a follow-on fixture is not recoverable under the first limb of Hadley and Baxendale unless the party in breach assumed responsibility for the loss. I note opposing counsel's submission here that the test of assumption of responsibility is only to be applied in the unusual case, and opposing counsel there referred to the case of the Sylvia. However, in the Sylvia, Mr. Justice Hamblin noted at paragraph 40 that the two factors that make a case an unusual one requiring the application of assumption of responsibility are the prevailing market understanding and the unquantifiability of the loss. As to the prevailing market understanding, opposing counsel also submitted that the same understanding that applied in the Achilleus, that damages do not extend to a loss of profit under a follow-on fixture, should not be taken to apply here. And they relied on the case of the Sylvia as saying that damages may sometimes be recovered for such loss. However, we note importantly that the case of the Sylvia concerned an entirely different market. That is the market for a subcharter during the currency of a charter party. And Mr. Justice Hamblin acknowledged that that kind of loss may be recoverable under the first limb. However, Mr. Justice Hamblin did note that it would not be recoverable in the kind of markets that the Achilleus concerned, and that is the market we are dealing with here. Opposing counsel also placed reliance on the market volatility in the Achilleus, but that was not considered to be a factor requiring an assumption of responsibility in the Sylvia. The two factors, firstly, the prevailing understanding in the commercial shipping market, and secondly, that the loss is unquantifiable, are present here. As to that market understanding, I note that in the Achilleus, Lord Roger explained the rationale for this understanding, and that is present here. And here I'd ask the Tribunal to turn to tab 5 of our bundle of authorities. And this is the case of the Achilleus.
Tab 5?
Yes, tab 5, and then you'll see a flag for paragraph 54. And I'd invite the Tribunal to read paragraph 54.
That's at page 79 of tab 5. Carry on.
So here you'll see that Lord Roger explains that parties entering a charter party would contemplate that if the owners lost a fixture as the result of a late redelivery, they would then be in the position to enter the market for a new fixture, and the availability of the market would protect them from loss. And indeed, this is exactly what has occurred in the present case. Just 6 days after this charter was cancelled, the claimant was able to secure a substitute fixture for the vessel. The second factor, that the loss is completely unquantifiable, is also present here. And we do note opposing counsel's reliance on the chatter posts extracted at page 1 of the record, which indicate that they were looking to fix the vessel for 3 to 5 years. However, the parties to the present dispute concluded a fixture of 50 to 55 days, and on that basis we submit the respondent would infer that the claimant was prepared to fix for any period at all, and could therefore not meaningfully quantify its potential liability, such that it would assume responsibility for it. The Achilles being analogous in the material respects, we submit that the same result must follow, and this loss is not recoverable under the first limb. The only way, therefore, that this loss can be recovered is if it is deemed to fall within the second limb of the rule in Hadley and Baxendale. And the only evidence the claimant can point to establish that the respondent had special knowledge of this loss as required by that limb is those chatter posts I referred to earlier. At the outset, we do note that there is no evidence on the record that the respondent in fact saw these posts. However, even accepting that the respondent did, we submit that the bare suggestion that the claimant was looking to fix for 3 to 5 years falls far short of the standard required to establish special knowledge. I note that opposing counsel here relied on the statement of Lord Hope at paragraph 36 of the Achilles, that what the party in breach needs is some information to enable it to assess its potential liability. However, there, his lordship was talking about quantifiability of loss in respect of whether a party has assumed responsibility, and that concerned the first limb. This should not be taken to be an indication of what establishes special knowledge under the second limb.
I'm going to interrupt you for a moment. Back to that post of March 1st on page 1. What is your submission about the lack of knowledge on the part of the respondent of this expression from the owners?
Our submission is that even taking the position that the respondent had this within its knowledge, the suggestion of an intention to fix for 3 to 5 years is not sufficient. And we rely here on the guidance which was given by Lord Roger in the Achilles as to what would suffice to establish special knowledge in this kind of case. And I'd invite the tribunal to turn to paragraph 59 of that decision, and it should be flagged. It's behind tab 5.
Okay.
In London arbitration, people don't flag the paragraphs, so thank you very much.
We note that at this paragraph 59, Lord Roger states that the loss of profit under a follow-on fixture might be recoverable under the second limb if the owners drew the charterer's attention to the existence of a forward charter of many months' duration for which the vessel had to be delivered on a particular date. By reason of the chatter posts, the respondent had none of the knowledge referred to by his lordship. First, the respondent did not know whether the claimant had in fact secured such a fixture. They merely expressed their aspiration to do so, and we note that the fixture with Champion had not been concluded at the time of contracting. Second, the broad range of 3 to 5 years does not allow the respondent to meaningfully assess its potential liability. And third, the claimant at no point informed the respondent that the vessel had to be delivered by a particular date in order to avoid the cancellation of a subsequent fixture. In our submission, therefore, the respondent did not have the requisite special knowledge, and the loss of profit under the subsequent fixture is not recoverable. Turning to our alternative submission, and this is at paragraph 2 of our written outline, even if this loss was not held to be altogether too remote, we submit that it would nevertheless be limited to the initial 2-year period of the charter party and would not include the option which was exercisable by the subsequent charterer. I note the opposing counsel's reliance on factors such as avoiding the need to renegotiate a new charter party. However, in our submission, the exercise of the option would turn substantially on the market rate at the relevant time, and the claimant has not brought any evidence of what that rate was, even though that point passed approximately a year ago. And here it is therefore a purely speculative chance, and it is not appropriate to oppose an additional $7 million of liability on the respondent.
But do you accept that the option, if it was favourable, would be exercised in favour of the claimant, or the claimant is deemed to exercise a favourable option?
If the market rate was favourable,
yes,
then we accept that there would be
yes,
a stronger chance that the option would be exercised.
Yes.
However, we do note that even in that case, damages for that 2-year period would still need to be reduced proportionate to the percentage chance of the option being exercised, whatever that may be assessed to be.
Right.
Our final point on redelivery is at paragraph 3 of our written outline, and this concerns the claimant's duty to mitigate. The claimant did concede that it must give credit for hire under the substitute fixture with Fairwind International. However, what the claimant did not address is that it was also obliged to take all steps that a reasonable and prudent party would take to mitigate its loss in the ordinary course of business. and in that case, the claimant would be obliged to continue to seek employment for the vessel throughout the period of the fixture that was lost. Now, there is
the burden
no...
of proof not on you, though, to actually find examples of what they could have done?
We do admit that the burden of proof in establishing a failure to mitigate is on the respondent.
Yes.
The evidence that we can point to on the record here is that there was a ready market for the vessel, which is shown by the rapidity with which the claimant secured the substitute fixture. Beyond that, the claimant's own contracts would be within its knowledge, and we would simply submit at the highest that there is a strong inference here that the claimant failed in its duty to mitigate. Turning then to the issue of hull cleaning. The claimant here is seeking damages of over $96,000 for the cost of cleaning the vessel's hull. We do not contest that the respondent was under an obligation to clean the hull. However, we say the respondent was prevented from doing so under Clause 83D of the Charter Party and is therefore liable only to pay a reasonable lump sum to the claimant. Turning first to the issue of prevention, and I'm now at paragraph 4A of our written outline. In our submission, a charterer is prevented from cleaning where performance has become disproportionately burdensome, and a stricter meaning should not be given to the word prevented here, as a finding that a charterer has been prevented from cleaning simply leads to an alternative mechanism for performance.
Yes, but what's the factual basis for your argument?
In our submission, the respondent attempted to conduct cleaning and was precluded from doing so by circumstances outside its control, including the claimant's own conduct. First, of course, as opposing counsel noted, the respondent could not clean the vessel at Wahunda. We do not contend that that itself amounted to prevention. However, we note that the vessel was detained at Wahunda from 7 May when it arrived until it was granted free pratique on 26 June, and of course it remained impossible to clean throughout that period. Once the vessel was granted free pratique, our client immediately made an offer to have the vessel cleaned at the port of North Titan, and this was the closest port within the Wahunda range. The claimant refused this offer, and in our submission we could not proceed with cleaning without the claimant's consent, as we were required to conduct cleaning in consultation with the claimant. The claimant then demanded on 29 June that our client clean the vessel at the port of South Island, which we note was further from Wahunda than North Titan. At that stage, the maximum period of the Charter Party had long since expired, and in our submission, the appropriate measure of damages for that breach of late redelivery is accruing for each day of the overrun. At that stage, therefore, it would have been disproportionately burdensome for our client to sail to South Island, first because it was more expensive to sail there than it would have been to North Titan, and because we were accruing damages for each day of redelivery. Moving then to the appropriate quantification of the lump sum in this case, we say the lump sum should be limited to the sum of $33,000. And this is based on the quotation that our client sought from Titan shipbuilders, which established cleaning could be conducted at that cost. And in our submission, the special circular to the BIMCO clause, which can be found behind tab 1 of our bundle, confirms that this quotation is the appropriate measure on which to assess the lump sum. If I could ask the tribunal to turn to page 3 of that document behind tab 1.
Sorry, your bundle?
Yes, our bundle at tab 1.
Yes?
On page 3, you'll see a highlighted quote which states that a lump sum agreement may not always reflect the exact amount of the owner's costs and expenses, as it will be based on quotes from cleaning companies as opposed to actual invoices. It is not to the point here that the actual cost incurred by the claimant in cleaning the vessel did exceed this $33,000 sum. The claimant was entitled to take the vessel to South Island after redelivery in its own private interest. However, the respondent can not be now liable for increased damages as a result of the claimant's own choice.
Could I put a forensic question to you? You're entitled to refer to BIMCO comments on a BIMCO clause.
Yes, Mr. Arbitrator. There's a case from 2012 called the Triton Lark, where Mr. Justice Tier confirmed that resort may be had to this special circular in construing the BIMCO clause, as it is part of the information that would have been available to the parties at the time they made the contract. Finally, in our submission, the costs of the voyage to South Island should not be included in the appropriate quantification of the lump sum. Clause 83D does provide that the lump sum payment is to reflect the expenses arising in connection with cleaning. However, we say that the phrase "in connection with" should be taken to cover only such things as vessel disbursements and port agency fees during the period of cleaning, and not the expense of the voyage to the cleaning location. This construction avoids the potential for an uncommercial result. That is, if the charterers must compensate the owners for all expenses of the voyage, the owners are effectively left at liberty to arrange cleaning at whatever location they judge best in their own interest, and could therefore force the respondent to incur costs significantly in excess of those required to conduct cleaning itself. If I may be of no further assistance to the tribunal, that concludes my submissions.
Thank you. When you're ready.
Thank you, Madam President and members of the Tribunal. As noted by my colleague, I will be addressing the third and fourth submissions for the respondent, dealing with the counterclaim for an indemnity against liability for the damage to the cargo of English breakfast tea, and the counterclaim for damages reflecting the overpayment of hire, respectively. Moving to the first of these submissions, as to the cargo damage, the respondent seeks a declaration that the claimant is obliged to indemnify it against 100% of its liability to the third-party cargo receivers for the damage to the tea in this case. This submission proceeds in three parts. Initially, at point 5 of our written outline, we submit that liability for the cargo claim is to be apportioned according to the terms of the interclub agreement. The agreement has been incorporated into the charter party by reference in this case in clause 53 of the Omega Rider and clause 27 of the NYPE form. Now, we note immediately here our learned friend's contention at paragraph 3.1 of their written outline that apportionment under the agreement is not enlivened because the cargo claim has not been properly settled or compromised and paid, in accordance with clause 4C of the agreement. We of course recognise that the cargo claim brought by the receivers truly has not been paid. However, it is for this reason that we seek declaratory relief here, apportioning liability according to the percentage figures set out in the interclub agreement in anticipation of payment. This precise relief was granted by Judge Waxman QC, sitting as a judge of the High Court of Justice in the 2018 case of the Maria, and we do note that this tribunal is empowered to grant declaratory relief pursuant to section 48, subsection 3 of the UK Arbitration Act 1996. We acknowledge at point 6 of our written outline then, the claimant's pleaded contention that the cargo claim here is time barred according to clause 6 of the agreement. And I invite the tribunal to turn now to this clause. The claimant's contention is specifically that the written notification provided by the respondent in accordance with this clause was not sufficiently detailed, and the detail here pertains to those three matters listed in the final sentence of clause 6. That is, first, the contract of carriage between the respondent and the third-party receiver, secondly, the nature of the claim brought by the receiver, and thirdly, the amount claimed. At point 6A of our outline, we respectfully submit that the claimant's contention should not be accepted. The written notification has been given to the requisite standard within the prescribed 24-month period.
And is in that regard, are you relying on the email of July 7th, 2016, found at page 45 of the materials?
We are, Madam President, along with the preliminary survey report extracted on the following page of the record that was annexed to that email. Before moving to consider this precise notice on the record, we do make three preliminary submissions as to the construction of clause 6 itself. First, the phrase, if possible, in the final sentence of clause 6 is merely conditional. We submit that the listed items of information therefore need only to have been provided to the extent that they were available to the respondent during the 24-month period. Secondly, we submit that the word details in that sentence should be taken to mean material details and not necessarily all details. We submit that, practically speaking, the failure to provide an immaterial detail should not time bar a claim. Finally, further to this construction of materiality, we acknowledge that the purpose of the time bar here is simply to allow the claimant and its club to be sufficiently informed to investigate and prepare for the forthcoming cargo claim. We submit that it accords with this pragmatic purpose that a material detail is taken to be one that the claimant did not already know. Again, the agreement would take on an unusually draconian aspect if the respondent could be time barred for failing to notify the claimant of a detail it already knew. Proceeding on this construction, I invite the tribunal to open page 46 of the record and consider the preliminary survey report there set out. The The survey report and its covering email were provided well within the 24-month period, and we submit that this survey report contains the 3 listed matters in Clause 6 to a sufficient standard. First, we submit that the first and second paragraphs of the report clearly disclose the nature of the claim. That is a claim for severe water damage to a cargo of English breakfast tea occasioned by an error of a crew member during ballasting. Secondly, as to the amount claimed, we submit that the report provides ready grounds for an estimate of the cargo claim. In the first paragraph of the report, it is stated that the cargo consists of 8,600 metric tonnes of tea. In the third paragraph, it is stated that the majority of this tea was damaged, and in the fourth paragraph, this cargo is estimated to be valued at between $60 and $65 per kilogram. From this, the claimant and its club could approximate the quantum of the cargo claim and proceed to take preparatory steps accordingly. Finally, as to the contract of carriage, though the full contract, evidenced by the draft booking note at pages 47 through 49 of the record, was not sent to the claimant, many of the terms in that contract were not material details on our construction of Clause 6. What is material in a contract will naturally vary from case to case. However, in the absence of any unusual or onerous terms, we submit that the key material details will ordinarily be, first, the identity of the contractual carrier, a fact which decides against whom the cargo claim will be brought, and secondly, the rules that apply under the contract, which may influence the nature and quantum of the claim that might otherwise be gathered from the report. In the present case, we submit that there are no irregular or onerous terms in the contract of carriage, and that these 2 aforementioned details were provided or were otherwise already known.
How were they known?
As to the first of the listed details, the identity of the contractual carrier, this is simply stated in paragraph 4 of the preliminary survey report in the final sentence, where the respondent is identified. As to the rules, we know from paragraph 1 of Procedural Order 2 that Chalaland, the country from which the goods were shipped, had laws closely resembling the laws of the United States. The United States, of course, has the Carriage of Goods by Sea Act, an amended version of the Hague Rules that critically applies to all contracts for carriage to or from the United States.
Sorry to interrupt you, how could the owners' club or the owners assess what claim might come home to roost? I take your point that they know what the cargo was and that it's a potential total loss, and so they got the value of the cargo. But there could be a total let-out clause. There could be a package limitation argument. I realise this was in bulk, but there are these issues which you can only really identify when you have the contract. And the interclub agreement is supposed to be essentially just a mechanical accounting exercise, really. And the club there would just actually be quite in the dark, wouldn't it?
That is potentially the case, Mr. Arbitrator. However, we note that the full terms of the bill here are set out on page 48, and there are no such unusual or onerous terms in this case that the respondent even could bring to the claimant's attention. We submit that knowing the rules, the claimant and its club might know what duties that the receiver alleged were breached, what defences might be available, and of course what limitations might affect the quantum of the claim. This is not a case where these matters were left at large by a failure to provide the contract. Accordingly, the 3 listed details having been provided within the prescribed period, we submit that the respondent has provided sufficient written notification here. At point 6b, we note very briefly an alternative submission, and that is that if the tribunal is minded to find a breach of the shall, if possible, detail obligation, we submit that Clause 6 should be read as 2 separate obligations, one arising from the first sentence to provide written notification within 24 months, and the second from the second sentence to provide notification, including, if possible, the listed details. We submit that these obligations should be read separately, with the result that if the written notification that was given here was insufficiently detailed, this merely entitles the claimant to damages, perhaps reflecting the prejudice suffered in their preparations.
If I may interject again, I think that's an over-sophistication of this agreement that is supposed to really be, as I said earlier, an accounting arrangement between insurers.
That may be so, Mr. Arbitrator, and in that case we would rest most heavily on our first
argument.
alternative.
Yes, I think so.
Moving then to the apportionment mechanism, and this is at point 7 of our written outline, we submit that apportionment should follow under clause 8A of the Interclub Agreement, to which I would invite the Tribunal to turn. Specifically, we submit that the damage to the cargo here arose out of an error in the management of the vessel, making it 100% for the claimant's account. The heart of the dispute here is the distinction between an error in the management of the vessel, which might indirectly affect the cargo, and a want of care of the cargo itself, which we do acknowledge would be apportioned under clause 8B. According to Mrs. Justice Cockrell, in the 2018 High Court case of the Provotion, this distinction must be drawn according to the primary nature and object of the acts which caused the loss. Ballasting is ordinarily undertaken by the crew to ensure the safety and stability of the vessel. In the present case, we have a clear statement of the circumstances in which the ballasting was conducted. Paragraph 1 of the preliminary survey report states that the crew were taking steps to ballast the vessel, ready for her departure once the cargo had been discharged. From this, it can readily be inferred that ballasting was conducted to ensure the integrity of the vessel and to prepare her for her coming voyage. The operation was therefore directed at the vessel and not at the cargo, and so on the authorities we submit that it must follow that the primary purpose of the ballasting was therefore the management of the vessel. We do note briefly our learned friends' reliance in their written outline of the case of the Eternity in their submission that apportionment should follow under clause 8B. This decision might, on its face, seem to state a refinement of the primary purpose test, encouraging consideration of the precise apparatus in issue, use of which resulted in the damage. However, the error in this view of the Eternity is apparent when one considers the distinct facts in that case. There, the damage resulted from misuse of valves in an inert gas system, and that system is installed for the protection of the ship. However, critically, the use of the valves and the resulting damage in that case occurred while the system itself was not in use. The valves were negligently left open, and vapours from one cargo flowed through the system to another, contaminating both. Accordingly, when characterising the nature of the error in that case, Mr. Justice David Steele did have reason to look at the use of the precise valve, because there was no broader primary purpose to consider. It is not correct to apply that decision here. Moving finally to off-hire, we submit that the respondent is entitled to damages for the claimant's failure to refund overpaid hire, as the vessel was off-hire between the 7th of May and the 26th of June 2016. The central question in this case is whether the vessel was off-hire, and at point 9 of our written outline, we submit that it was under clause 17 of the NYPE form, to which I invite the Tribunal to turn. That is on the 10th page of that NYPE document.
Is that in your,
It is in the plastic sleeve at the front of our bundle.
okay, clause 17?
Yes.
Yes?
Now, the off-hire mechanism in this clause operates in two parts. In accordance with the words at line 379, the full working of the vessel must be prevented. And secondly, this prevention must result from a previously listed cause. Stepping through the mechanism, at point 9A of our outline, we first submit that the full working of the vessel was prevented here. The vessel was not efficient to do what she was required to do when called upon to do it, as she was quarantined and held at anchorage by port state control.
Is there not some law that says that it's got to be the vessel qua vessel? It's got to do with the physical structure of the vessel.
It was noted by Mr. Justice Ricks, Mr. Arbitrator, in the High Court case of the Laconian Confidence, that it could be legitimate to find that the full working of the vessel has been prevented by action taken by authorities. So it is legitimate to look beyond the vessel itself.
How does clause 44 help you?
In this case, Madam Arbitrator, we submit merely as an alternative that clause 44 would apply to render the vessel off-hire, and that is because the vessel has called at the port of West Coast, where there was an Ebola outbreak. The crew of the vessel have had contact with that shore, and that was done without the written consent of our party. However, we prefer to rest our case here on clause 17, and specifically the words any other similar cause in that clause. The words any other similar clause were interpreted in the case of the Laconian Confidence to extend again to action taken by authorities. Specifically, Mr. Justice Ricks said that where authorities act properly or reasonably pursuant to a suspected inefficiency of the vessel, any time lost may be off hire. Considering this principle, we first note that the phrase suspected inefficiency of the vessel was taken by Mr. Justice Ricks himself to include suspected disease amongst the crew. We submit also here that the authorities have acted reasonably, enlivening the principle. Knowing that the vessel had called at the port of West Coast, where there was an Ebola outbreak, we submit that it was perfectly reasonable for Port State Control to take the precise measures they did, detaining and quarantining the vessel on a suspicion of Ebola virus amongst the crew. For that reason, we say that Clause 17 is enlivened and the vessel was off hire for the period. If I may be of no further assistance to the Tribunal, this concludes my submissions.
Thank you.
Madam President, members of the Tribunal, we make two submissions in response on the counterclaim. First, the claimant is not liable to indemnify respondent for the cargo claim, and second, that respondent is not entitled to restitution of, nor damages for overpaid hire. Turning first to the cargo claim, there are 3 points of contention between the parties, and I will address each in turn. First, whether the fact that respondent has not paid the receivers means the interclub agreement cannot be applied due to a failure to satisfy Clause 4C. Second, whether the claim is time-barred due to the application of Clause 6. And third, whether claimant in the alternative is only liable to indemnify respondent for 50% of the cargo claim, applying the apportionment regime in Clause 8. If the Tribunal finds for us on either of the first two issues, then we are not liable to indemnify respondent for any of the cargo claim. However, if the Tribunal finds only for us on the third issue, then we are liable for 50%. The interclub agreement can be found at tab 8 of our bundle, and the key clauses, as mentioned for the purposes of our submissions, are clauses 4, 6 and 8. Turning first then to clause 4C, it has been put against us by respondent that although acknowledging that the claim has not been paid, but this does not prevent this tribunal from making a declaratory order. Whilst they referred to a 2018 English, Wales and High Court decision in which such an order was made, our submission is that in that case it was not at issue between the parties or not contested that clause 4C was satisfied. On our submission, however, clause 4C is a strict precondition and has been held by courts in the past to be such, and that therefore if the tribunal were to make the particular award the respondent seeks, then this would actually be contrary to the very scheme of the interclub agreement. We note that this was suggested in the Strathnewton, a 1983 decision of the Court of Appeal, the 1992 decision of the Holston Cruiser of the Queen's Bench Division, and also is held to be a strict precondition by reference to those earlier cases in the Cargo Explorer, which was a 1995 decision of the South African High Court.
But if we made a declaratory award, as has been suggested, and it simply said that in the event of the claim being paid, there would be a liability, would that actually prejudice you in any way?
Our submission is that although it may not prejudice us, it would be contrary to the very scheme that the parties have agreed to. And we note that Mr. Arbitrator noted earlier that the interclub agreement is a mechanical scheme of apportionment.
Yes.
In order, therefore, for P&I clubs to have certainty and to avoid undue expense, it has been held by courts in the past that a general principle, Clause 4C, and the payment of that underlying claim is to be a strict precondition.
Thank you.
For this submission, we further rely upon the fact that the interclub agreement was amended in 2011 to include a security clause. This provides a particular exception to the requirement in 4C that the underlying claim be properly settled and paid. However, instead of taking that opportunity to amend Clause 4C and make it a less strict precondition, the drafters of the interclub agreement instead reinforced the fact that Clause 4C is to be read strictly by providing for limited circumstances in which that will not operate strictly. On our submission, therefore, the very scheme that the parties agreed to required payment of that underlying claim in order for apportionment to occur, and therefore the tribunal should not proceed to apportion the dispute. However, even if the tribunal were not minded to accept our first submission, we submit in the further alternative the tribunal should not proceed to apportion the claim because it is time-barred under Clause 6. In particular, respondent has responded to our argument by saying that the standard here is only to provide details if it were possible to do so.
But that's the language of of Clause 6.
And we agree with that construction, Madam President. However, our submission here is that even applying their characterisation, there were material details that it was possible for respondent to provide that were not in fact provided.
Such as what?
Such as a copy of the contract of carriage. It can be inferred from the fact that respondents had concluded an agreement with the receivers and also acted in performance of that agreement by shipping goods pursuant to the charter party between these parties, but they had in their possession a copy of that contract of carriage at the date when written notification was provided, 7 July 2016. Now, this has two important commercial implications. First, it meant that claimants could not determine whether the precondition under Clause 4A of the ICA was satisfied. And this is for two reasons. First, we did not know whether the contract with receivers was authorised under the charter party, as required by Clause 4A, Part I. And second, we did not know whether the contract with receivers incorporated terms no less favourable to the Hague or Hague-Visby rules. The second reason is that claimant could not determine the precise legal relationship between respondents and receivers. As was noted in questioning by Mr. Arbitrator earlier, we did not have access to the precise contract, and therefore there could have been any given clause inserted in there that would have in particular affected respondents' liability to the receivers.
But affecting responsibility is not the same as affecting a relationship.
We note that, however, we rely upon the fact that the relationship between respondents and receivers and the liability involved in that relationship would have an effect upon whether we were in fact liable to indemnify respondent for any claim made against them, and also affected our ability to know whether we in fact would have to prepare a claim in defence to that claim made against us. We note that respondent has said that in response to this submission, the particular draft that was extracted in the record did not have any unusual terms. However, as a general matter, it need be considered that we did not know that it did not contain these particular terms. How are we to know that it did not incorporate a particular term that would have affected that liability? And so as a general principle, given that it was salient for our ability to prepare and investigate the claim as understood, applying the language of Clause 6, the claim was indeed time-barred.
Could I take you out of turn, and I'm going to ask Madam President to allow you the extra time that it takes to answer to this question. I didn't understand, but that's my failure on my part, your argument on security, on the question of construction, and I'm sorry to take you back to it. Do you remember you said that because they subsequently agreed a revision with security?
Of course, Mr. Arbitrator, I'll address that now.
If you wouldn't mind.
I can't give him extra time.
Oh, apparently you're not allowed extra time.
Never
Can
mind,
you do it?
we won't eat into his time now by discussing that. Carry on.
I can address that question in brief if the tribunal would.
Yes, please.
In brief, our submission is that provides for a limited exception to the requirement that the claim be paid.
Right.
And so on our submission then, it reinforces the fact that 4C is to be interpreted strictly because the P&I Club, or the drafters of the Interclub Agreement, had an opportunity to amend 4C and instead upheld it by providing a limited exception to it.
Thank you. I understand that now.
Turning then to our further alternative, if the tribunal does not find for us on Clause 4 or 6, we turn to the apportionment regime outlined under Clause 8. Our submission, contrary to respondent, is that the claim here falls to be apportioned under Clause 8B of the Interclub Agreement, on the basis that the claim arose out of the storage of cargo and that the words "and responsibility" were added to Clause 8 of the NYPE, this being done at page 5 of the record. And this corresponds to paragraph 3.3 of our written outline. Now, we acknowledge here that the act of ballasting would ordinarily, or is, in the management of the vessel. However, here, the relevant error, and we note that the language of Clause 8 looks at claims in fact arising out of, and therefore imports causation, was the opening of a valve, the closure of which ensures that water does not go into the cargo hold. Accordingly, it therefore serves the purpose of protecting the cargo and applying that purpose test that was laid out by respondent. It's our submission that it falls particularly within Clause 8B. In drawing this distinction between the overall purpose of ballasting and the purpose of this particular part, we rely upon the House of Lords decision of the Canadian Highlander, in which their lords referred to the words of Lord Justice Greer, dissenting in the Court of Appeal decision that were upheld by their lords, that if the cause of the damage is a neglect to take reasonable care of the ship or some part of it as distinct from the cargo, the ship is relieved of liability. But if a negligence is not negligence towards the ship, but only negligent failure to use the apparatus of the ship for the protection of the cargo, the ship is not so relieved. That is precisely what we say has happened here, given that the apparatus of the ship was failed to be used for the protection of the cargo. On that basis, we submit that even if the tribunal does not find for us on our earlier submissions, we are at most 50% liable, but we rely principally upon those first two submissions. I'll turn then to our second submission regarding off-hire. It was put against us by respondent that the vessel was off-hire pursuant to either Clause 17 or Clause 17 of the NYPE or Clause 44 of the Amiga Rider Clauses. We note that they principally relied upon Clause 17, but responding briefly to their argument on 44 first, this can be found on page 9 of the record, and it requires that, in order to apply, any communication that occurred with the shore or an infected area must have occurred without the written consent of charterers. Now here that was not the case for two reasons. First, any communication that occurred was in performance of the charter party that had been concluded between the parties. And second, if I could take the tribunal to Clause 68 of the charter party, and that can be found on page 13 of the Moot problem. That clause outlines duties and responsibilities of owners and their crew. And in particular, Part A4 outlines that there are to be on board sufficient personnel inter alia to enable communications between the vessel and those loading the vessel to be carried out quickly and efficiently. Those two reasons, we say, therefore demonstrate the consent was given in writing, and accordingly the vessel was not off-hire pursuant to Clause 44. Turning then to the submission that it was off-hire pursuant to Clause 17 of the NYPE, we note as a starting point that as owner, a claimant has a prima facie right to hire. And since the off-hire clause provides for derogation from this right, respondent bears the burden of proof. And accordingly, any ambiguity must be resolved in favour of claimant. It is established in the Court of Appeal decisions of the Alissos and the Doric Pride. Now, respondent has primarily relied upon the off-hire event, a similar cause preventing the full working of the vessel. They relied in particular upon the obiter of Mr. Justice Ricks, as he then was, in the Court of Appeal decision of the Laconian Confidence. However, after the section of that judgment that respondent took the tribunal to, Mr. Justice Ricks went on to note that the presence of the word whatsoever in the off-hire clause may have facilitated the finding that a vessel suspected of carrying typhus in an earlier decision of the Apollo was off-hire. And now in those prior decisions, the presence of whatsoever was held to preclude an eusdem generis construction being applied. That is, it meant that the sweeping up clause did not have to be interpreted by reference to being of a similar type to the particular causes listed in the clause. Given that uncertainty in that obiter passage, it is our submission that it is plainly unclear on the authorities whether a vessel suspected of carrying a serious illness does in fact fall within the meaning of any other similar cause. In advancing this submission, we further rely upon the fact that this case is in any event distinguishable from that of the Apollo. In that case, two members were taken off the vessel at an earlier port suspected and then later found to be carrying typhus. The vessel then progressed to a subsequent port where it was detained for inspection for 29.5 hours before being granted free critique, and the vessel was off hire for that period. In the present case, however, there is no evidence on the record that any crew member was ever found to have Ebola. The vessel, despite that, was detained for 5 days prior to inspection and then for a further 45 days after inspection. All that was found upon the inspection, and though we note this is disputed between the parties, at the very most was a number of crew members of a high fever. In fact, according to our clients, the condition was only that two members had a cold.
But the vessel couldn't be worked.
We acknowledge that the vessel could not be worked. Yeah. However, our submission is the full working of the vessel was prevented by the detention, and that detention does not fall within the scope of the off-hire clause here. There are two issues here. First, whether the full working was prevented, and second, whether the particular cause of that full working falls within the particular off-hire clause. It's our submission that it does not.
But what about the role of port state control?
We note that Port State Control act to prevent the spread of any potential illness here. We submit that they may have been justified in initially detaining the vessel. At the very least, our alternative submission is the vessel was not off hire for the entirety of that 50-day period. Because even applying the Oberter test that was outlined by respondent, our submission is that they did not act reasonably or properly pursuant to the suspected condition of the vessel in detaining the vessel for the entirety of that length of time. On that basis, we submit first that respondent is not entitled to any overpaid hire, but in the alternative only for some of that. If I can be of no further assistance to this tribunal, those are our submissions.
Thank you. When you're ready.
Madam President, members of the tribunal, on hull cleaning, the respondent submitted that in the present case, damages need be capped at $33,000 pursuant to clause 83D. We submit that this is an error of law because in Robinson and Harmon and Victoria Laundry, it was held that a party is entitled to be put in the position they would have been, but for a breach of a particular term. Here, the position that the claimant would have been in, but for the breach of subclause D, is that they would have been able to negotiate a sum that allowed them to account for all the expenses associated with cleaning. Here, cleaning at South Island and the extra costs associated with it clearly fall within that scope. And that's because additional cleaning services were available at South Island that were not available at North Titan, and therefore clearly arose in connection with the need to clean. That's it, Madam President. Thank you.
That is the conclusion of your submissions.
Yes.
The panel will retire. A decision will be circulated in due course.
And we won't be influenced by the fact that destroying English breakfast tea is a sacrilege.